have. So we're just going to get started, jump right in with that. So everyone should have a basic set of estate planning documents. What makes a great set of documents? There's really four primary documents that I'm talking about when I say an essential set of estate planning documents. You need to have a general durable power of attorney, a healthcare power of attorney, a living will, and a last will and testament or living trust with a pour over will. So the general durable power of attorney, the healthcare power of attorney, and the living will are all documents you need to have that are used while you are alive. Obviously, the last will and testament is used once you pass away. So we're going to start with the general durable power of attorney. A durable power of attorney means that the authority conferred on the agent by the document is exercisable even if the principal later becomes disabled or incapacitated. That makes sense because most people think about their agent being able to act once they are incapacitated. So it's really important that the power of attorney is durable and lasts through that. A question I get asked very frequently is we have a consultation and maybe mom or dad or a spouse just had a recent diagnosis and they're realizing now they don't have any estate planning documents, and they say, well, we just got this diagnosis of dementia or some other cognitive decline, and people ask, well, can they even execute documents? Do they have capacity? That's a great question. The answer is, of course, it depends. The capacity to make a will is a lower standard than capacity in other areas of the law. So the capacity needed is a general knowledge of what the person executing the will has. So, they have to have a general idea of their assets. Again, if it's complicated, they don't need to know every single little detail, but a general idea of what they have and what they want to have happen. So there's enough self-determination there that, they say, I want all of my assets to be divided, among my kids equally. The other thing is having lucid moments. That's enough for capacity. So sometimes there are times when, they wouldn't have capacity to execute a document, but then the next day, as it happens with these kinds of illnesses, they might be completely lucid. And so, we can work around that to make sure that the person has capacity when they're executing the documents. It's important to make sure you have a set of documents, especially when someone gets a diagnosis, because if there is no set of documents, there's no power of attorney, no living will, healthcare power of attorney. If the person loses capacity and gets to the point where they can't execute documents, well, then the only option in Pennsylvania is a guardianship, which is a last case resort. And we never want anybody to have to go through that procedure, if at all possible, to avoid it. So back to the power of attorney document. Not all power of attorney documents are the same. Again, it's not the same thing as a guardianship, which is what I just mentioned. A power of attorney is delegating someone to act on your behalf, where guardianship actually takes away rights from the alleged incapacitated person. So oftentimes when we're reviewing the financial power of attorney with clients, the principal says, well, am I still able to, pay my bills, control my money, do all these things? And the answer is yes. The principal is not losing any of their ability to handle their own affairs. They're just granting that authority on their agent as well. A great power of attorney, the number one consideration, first and foremost, is obviously the choice of the agent. You're giving this person a lot of control over your finances. They have a lot of power. They also can have a lot of responsibility. So the choice of agent is important. Sometimes it comes up where parents are appointing adult children and they say, well, just appoint all three of them because they don't want anyone to feel bad. And that's really not a great way to determine who's going to be your power of attorney. It's a really important job. So it's most important to just choose the person who is best suited to serve in that role. You need to choose someone you trust and someone who's also able to manage finances. Your agent has a fiduciary duty to act in the best interest of the principal. And a question that comes up frequently is whether, it matters. I have a child who would be a great agent, but they live in South Africa. I mean, it can be inconvenient sometimes to have an agent who lives far away, but generally speaking, with technology being what it is, we really don't have trouble with agents not being in close proximity. So the first and foremost consideration is choosing someone you trust and who would be good for the job. And then if, let's say, you have two people who would both be great, then maybe you could consider where they're located. Just sometimes that can help make it a little easier, but that's really not a primary concern. If you already have a power of attorney, or if you are going through the process to do a new power of attorney, one thing to consider is gifting authority. So a lot of times you'll see, there's different options in all powers of attorney. Sometimes you'll see a power of attorney where it says all gifting is permitted. That can make people pretty uncomfortable to see, well, my agent can make any gifts at any time in any amount to any person. Again, you have to remember your agent has a fiduciary duty to you, but the unlimited gifting can be a little jarring to read. So sometimes you'll see a limitation on gifting. I was looking at one yesterday, and there's a limitation that it must be to a class of persons. So, for example, if you're making a gift to one child, it has to be to all children, things like that. So there's limitations. However, I will caution you that we also have issues sometimes with that when we're doing Medicaid planning with the gifting authority conferred on the agent in the prior power of attorney. So it's just something to consider, talk to the lawyer about, and make sure you really understand what gifting is allowed under the power of attorney. And back to what I said a few minutes ago, the agent is limited by the gifting provision, but the principal is not. The principal can continue to live his or her life and make gifts if that's what they were doing. It's also important that the power of attorney document complies with state law. You would think that would be obvious, that it must comply with state law, but believe it or not, we see it frequently where there aren't two witnesses, or it hasn't been notarized. And, when your agent goes to use it, they'll be turned away, and then you're kind of in a chaotic situation. In Pennsylvania, it's also required to have a notice page on the front of the power of attorney document. It's all in capital letters. It looks like we're yelling at you, but it must be in exactly that form. It explains the potential reach of the power of attorney, and it's meant to advise people not to sign the document unless they really understand it and it reflects their intent. The next thing.
You have a question.
Oh, okay. Sorry. Go ahead.
What type of tests do you use to determine capacity?
Yeah, that's a great question. So, a lot of times when we, for our law firm, we have two elder care coordinators as well who are licensed in social work, who are meeting with clients. So we use them as well if somebody has had a diagnosis. But really, it's just having the conversations, making sure, do they understand? Do they have the self-determination? Do they know what they have and what they want? And, we go over all of the documents with each client before signing. We have a review call to make sure, and then also at the signing appointment as well to confirm the choices that were made. So it's obviously a case-by-case basis. Like I said, there's no, just because you have a diagnosis, that doesn't preclude you from being able to execute documents. So it's really just having those conversations and making sure that the lawyer meets with the client specifically and make sure that the document reflects their wishes.
Okay. Can two people be given POA and share the responsibility?
Yes, that is quite frequent. It can be daunting to, when you're naming a power of attorney, if you're naming an adult child or a friend, I mean, it can be a lot of work. So a lot of times people name two agents to serve together. One kind of a funny story is that I had a client who was naming his two daughters to serve on everything, together as executor, as power of attorney. And I said, as we went through it, I said, oh, well, I'm assuming they work well together because you're naming them on all of your documents. And he said, well, they haven't spoken in 15 years, but they'll figure it out. And it just reminded me how crucial it is that if you're naming two agents, you need to make sure they work well together. If there are personal issues, then that's really not a good choice. But otherwise, it's a great option to have two people serving together. Allie, any other questions for right now?
Good for right now.
Okay. So I was just about to say, when is the document effective, a power of attorney? So there are really two options. The document can be effective immediately upon signing. So you go to the lawyer's office, you sign the documents, it's witnessed and notarized, and you're set, which means your agent can that day go act on your behalf. Again, they have a fiduciary duty to act in your best interest, but they can act immediately. That can feel a little alarming for people, especially if the agent is not a spouse. However, oftentimes we really recommend that because it's a much smoother process if you do become incapacitated or you're just unable to act, because your agent can already step in and act on your behalf. If you have a document that's effective upon incapacitated, that's what's referred to as a springing power of attorney. And the issue is, it's just really difficult to have a doctor sign off, say someone's incapacitated. And usually, if that happens, you're at kind of a crossroads where you need to act immediately, and it's a tough situation, and yet the agent's unable to do that because we're waiting for a doctor to sign off and say the person is incapacitated. So again, every situation is different. Of course, there's times where that's appropriate, but generally speaking, we recommend for our clients that it's effective immediately upon signing, depending on the situation. In terms of when you choose your agent, it's important to have a conversation. Make sure your agent consents to being the agent, that they're up for the job. And this goes back to the question we just had. If they're not up for the job, is there someone that can serve as a co-agent? Maybe that would, take some of the burden off the person who's the agent. Have them actually read the document. Make sure they understand what their responsibilities are and answer any questions they have. That way, they understand what they're getting into and they're able to act because they know what's required.
Becky, can you clarify the power of attorney, principal, and agent? Because I feel like a lot of times they're used interchangeably, and sometimes it can get a little bit confusing. So those three, can you clarify for us?
Yes. Yep. So the principal is you as the person who is executing the power of attorney, the document. When I'm saying power of attorney, I'm referring to the power of attorney document. The agent is the power of attorney. So agent and power of attorney are used interchangeably, and the principal is the person who's appointing the agent / power of attorney. Was that clear, Allie?
Yep. One
Okay.
other question. If you have two agents for power of attorney, do they both need to sign the same documents? Do they both need to agree on each decision? If they do not, then what happens?
Yeah. So usually we recommend that each agent, if you have co-agents, that they have independent authority to act, meaning that each of your agent can go act. They don't need the other person there. They don't need their approval. The benefit of that is, it's very impractical to say the agents must act together because they'd have to go to the bank together. I mean, they just really have to do everything together, which really, it's not really something that's workable in the real world. When you have two agents that have independent authority to act. They can each see what the other is doing. They can keep an eye on the financial accounts. So let's say someone was doing something inappropriate, the other agent would see, and a court can always remove an agent who's acting improperly. But this again goes back to making sure you have two agents who work well together, who can trust the other one to handle any of the duties required. So another thing that comes up is power of attorneys. I actually saw one yesterday. It was signed in 1994. Documents executed after January 1st of 2015 must have the updated notice page, an agent acknowledgement where the agent actually signs to accept the position, and the signature must be witnessed by two witnesses and notarized. So documents before 2015 don't look like that. Technically, the older documents are grandfathered in. However, banks are getting more and more difficult to deal with for everything, not just accepting powers of attorney, just in general. So if your document's really that old, I recommend taking the time to talk to someone, think about whether it's time to update it, because trying to argue with the bank and saying, but legally you have to take this. I mean, it's just a lot of work. They don't really seem to care. They kick it up to legal. It can just really take a lot of time. And again, if it's a crisis, your agent needs to act, you may not really have that time. So it's just a good thing to update.
We have one more question before you move forward. If you have an agent that is not living nearby, how do you get their signature on the document?
Yeah, so what we do is we often email the agent acknowledgement page to them, and they can look at a PDF of the actual document. And then what they do is sign it in front of a notary wherever they are, and then mail it back, and then it's part of the document. When the agent goes to use the power of attorney, they can use a photocopy. They don't need the original. All right, so we talked about the requirements for the power of attorney. The other thing that changed after the new law in Pennsylvania dealing with the power of attorney is that it's a requirement that there's a specific grant of some of the powers. They're called hot powers. And Pennsylvania law prohibits the agent from taking certain actions unless specifically granted in the power of attorney. So again, if you have a document prior to this, it's a little more difficult because these powers might not be specified. The powers specifically that must be stated in the power of attorney are creating, amending, or revoking an inter vivos trust, the gifting power, change rights of survivorship in financial accounts or property, change or create a beneficiary designation, delegate authority under the power of attorney, waive the principal's right to be beneficiary of a joint and survivor annuity, exercise fiduciary powers, and disclaim property. So those are things now that must be specifically stated in the power of attorney document. I'm going to move on to advanced directives unless anyone has any other questions about the power of attorney.
We just had one question about just to clarify the requirements for post November 2015 for POAs versus pre-November 2015.
So it's actually January 1st, 2015, but the requirements, there's a notice page that was updated. So that is different than documents prior. I mean, there was a notice page, but it's not the same one that's used now. And then it's the agent acknowledgement that the agent has to sign and, that they are acknowledging and accepting the position. And then it's signed by the principal, witnessed by two witnesses. So it's signed by two witnesses and notarized. And then that's for it to be effective. But then the other things that are required after 2015 are those specific powers that I just mentioned.
Okay, thank you. One more before you move on. If a relative recently asked me to serve as POA, but nothing was sent to me to sign, I assume it is not effective. Is this a state-by-state requirement?
Yeah, so each state does have their own requirements, so I can't say for certain. So in Pennsylvania, if someone names you as power of attorney, but doesn't send it to you to sign, that's okay. The power of attorney document can be executed. The only thing is, and when the agent was actually going to act, then the agent would have to sign the document. So this happens quite frequently when we have very healthy, able adults. They'll tell their kids, listen, or whoever serving, they'll say, I did the power of attorney. You're named as my agent. But because you don't need to act, you can sign, there's no rush to sign the agent acknowledgement. So it's still a valid document, but the agent can't act until they actually sign the agent acknowledgement. Anything else about power of attorneys?
Nope, good to move forward.
All right. So next we're going to talk about advanced directives. Advanced directives An advance directive is a written statement of a person's wishes regarding medical treatment, including a healthcare power of attorney and living will. And Allie, if you want to move along in the slideshow, that would be great. Now, a living will is not a healthcare power of attorney. A healthcare power of attorney authorizes another person to make healthcare decisions for you when you cannot make them yourself. That person is your healthcare agent. Now, your healthcare agent's authority is standby only. So they have no authority to act until you are unable to make your own healthcare decisions as determined by your doctor. A living will, though, is a written declaration that instructs your doctor regarding the use, withholding, or withdrawal of life-sustaining treatment if you're terminally ill and lack capacity to make decisions. So that's two-part. You're terminally ill and you lack the capacity to make decisions. So sometimes people kind of forget about the second part, that you need to lack the capacity. If you're still, you can basically be about to pass away, but if you are still able to communicate your wishes, you can continue to make those choices. A living will directs your doctor's actions when the use of life-sustaining treatments would serve only to postpone the moment of death or maintain you in a permanent unconscious state. So it's a living will. There's sometimes a misconception of how often it's used, but it only applies in the very, very limited situation when you have an end stage medical condition or you're permanently unconscious and can no longer express your wishes. Now, what often comes up when we're talking about a living will is a DNR, or do not resuscitate order. A DNR empowers a terminally ill person or the person's surrogate to get a DNR, which directs EMS personnel not to provide the person with cardiopulmonary resuscitation in the event of the person's cardiac or respiratory arrest. So this does not go in the living will. It's actually a medical order. So your healthcare agent can request that it be put in your chart, but it's actually a medical order issued by the person's physician. I'm sure you've also heard of a POLST, Pennsylvania Orders for Life-Sustaining Treatment. In Pennsylvania, it's on a pink paper. It's very recognizable. That is also signed by a medical professional. It goes through treatment choices at the end of life beyond just resuscitation. So would you want full or limited medical treatment or only comfort measures? So it's a little different than a DNR. The question might be, well, why would you need a living will and a POLST? They really serve two different functions. They seem very similar, but a POLST, again, is a medical document. The living will is a legal document. A POLST will be followed by EMTs and hospitals because it's signed by the doctor or medical professional to direct immediate medical treatment, whereas a living will is a legal document that contains end-of-life preferences. The living will, the purpose, it's there to guide your healthcare agent to make choices that honor your wishes. Living wills are used more in a non-emergency situation, and it's there to direct future decisions about medical treatments. The other difference is a living will, you can make those choices now, execute a living will. A POLST is really for those who are seriously ill or frail. It's not really appropriate for someone who's in great health. You don't really need a pulse, but everybody should have a living will. Any questions about that?
Questions? Just what PULSE stands for again?
Pennsylvania Orders for Life-Sustaining Treatment. And it's easy to see because it's on a pink paper. So it's always on a pink paper, no matter where you get it.
And then the next question is the law in Pennsylvania still that absent a healthcare power of attorney, that the doctor has to do anything possible to keep you alive?
Yes.
Okay, I have a couple. Go ahead.
Go ahead.
I have a couple more. So is the DNR part of a living will or the healthcare power of attorney?
So neither. So as part of the healthcare power of attorney document, it will say, or at least our document says, I authorize my healthcare power of attorney to to request from the doctor a DNR, do not resuscitate order. But again, the doctor can say no. Like, for example, if I requested a DNR for myself, my doctor would probably say no. It'd say, you're in great health, you don't really need anything like that. So it's just not appropriate. So the doctor has the final say, but your agent can request it on your behalf.
My POA and my healthcare power of attorney are dated in 2013. Must I get these updated? Or when should you get them updated? Generally?
Yeah, you don't have to get them updated. They're grandfathered, they don't expire basically at any point. So again, it's just really if you actually try and use it, will it be effective? Maybe. I mean, you probably have more trouble with the banks than with the healthcare power of attorney, just because the banks are more difficult. The healthcare power of attorney, the law was updated in 2005, so yours looks probably very similar to what exists now. So you'd probably be fine. It's really just making sure that it's something that the medical community is used to seeing, because we all know they're very busy. They don't have a lot of time to spend looking at this stuff. So, make sure your choices are still correct. People change their minds, but just because they're, 12 years old, that doesn't mean that they are no longer good. They actually are still good. It's just more whether or not you'll have issues actually trying to use them.
And then is an advance directive the same thing as a living will?
Yes, an advance directive is the living will is a type of advance directive. Exactly. Yep. And that brings me into segue into my next point about advance directives. I know, Bally, you were on the right slide. Sorry. It's really the point of this is to have the discussion, have these conversation with loved ones, so everyone's wishes are known. It can be really difficult to have these conversations with family members or friends, but honestly, it's more difficult not to have them. There's a website I recommend checking out. It's called the Conversation Project. It's a public engagement initiative of the Institute for Healthcare Improvement. The goal is to help everyone talk about their wishes for care through the end of life so that the wishes can be understood or respected. It's also just helpful for family members so everybody understands the expectations and it doesn't cause conflict down the road. The Conversation Project has a really good thing that they say on their website, and what it is the time and place to have these conversations is at the kitchen table, not the intensive care unit. And I just think that's helpful. It's unpleasant, but the time is now to make sure that you have these conversations. I actually have a lot of people who come in for a consultation and they say, I just went through this with my parents. They hadn't done this. They don't have a living will, and it was very traumatic for our family, and I just don't want to put my kids through that. So I have heard that so many times. So it's just really important to make sure that you do this. And then the last statistic from the Conversation Project is that 92% of Americans say it's important to discuss their wishes for their end of life care, but only 32% of people have actually done so. So just make sure to do that and have those conversations.
Couple more questions.
Okay.
Are documents made in another state usable in Pennsylvania?
Yes, they are. So if it was valid in the state that it was created, then it is a valid document in any other state in the United States.
Next question. If a spouse dies without a will, does Pennsylvania require the assets are split with the living children and the surviving spouse?
So that's a great question. So Pennsylvania law of intestacy provides for different situations. If there's a spouse, if there's children from a prior relationship that aren't children of the marriage, and then you go through the law of intestacy to determine based on your family situation how it will be distributed. That's why it's really important to have a will, though. And the law of intestacy, it's, not super complicated, but honestly, it doesn't work for probably 99% of people when they actually figure out what would happen if you pass away without a will. The other complicating factor to that question is oftentimes married people have all of their assets held jointly. So usually there is no probate estate. Not always, of course, that's not always the case, but oftentimes we have it set up so at the death of the first spouse, their will doesn't have to be probated and everything passes by operation of law to the surviving spouse. So that's a great question, and that leads me into wills. But Allie, was there anything else about advanced directives before we get to the wills?
That's it for now.
Okay, so first, we'll start at the beginning. What is a will? A will disposes of your assets once you pass away. In order to have a valid will, the testator must be of sound mind and at least 18 years old. The will has to be signed, obviously. The best practice is for it to be witnessed by two witnesses and notarized. It doesn't have to be notarized for it to be valid, but it needs to be witnessed and notarized for it to be self-proving. A self-proving will is readily admitted to probate as valid. If it's not self-proving, so let's just say you just signed it but didn't get it witnessed or notarized, then the Register of Wills requires witness testimony to validate your will, which means basically it needs to be authenticated before admitting it to probate. It's just a pain, to be honest with you. If you're going through the trouble of making a will, have it be signed by two witnesses and have it be notarized. It just makes it a lot easier once you pass away. And we just talked a little bit about the laws of intestacy. So basically, if you don't have a will, it's not like, oh, the government gets it. But, we go through the laws of intestacy to see if they work. That's how things will pass. Generally, they don't work for most people. It's better to execute a will to make sure your probate assets are passing as you want them to pass. In terms of what makes a great will and estate plan, it's really important to have a complete and accurate asset list. So we can always go over with the client the non-probate assets, so retirement accounts, trust assets, real estate held by married persons as tenancy by the entirety, real estate held with another person as joint tenants with rights of survivorship, transfer or payable on death accounts. So you'll see that more and more frequently, TOD, POD on bank accounts, and life insurance. Those are non-probate assets. Anything else you own that passes by your will must go through the probate process. So that's, really any assets that's owned solely by the decedent. The will only deals with probate assets. So if you have other assets that pass by beneficiary or you've added transfer on death and payable on death to accounts, the will does not deal with that. So it's really important when we meet with families to make sure when we're coming up with an estate plan that we're dealing with all the assets, probate and non-probate. The assets that don't pass by the will, we want to make sure that the beneficiary designations make sense or that it lines up with the estate plan. An example of that is if we draft a will to include asset protection trust, sometimes for an adult child, and the parent says, okay, I want everything to go to my adult child in their trust, but then they never update the beneficiaries on their retirement accounts and their kids are just listed as the beneficiary. Well, because it's not going to them in trust, they will get that account outright. And so if you've gone through the trouble of setting up these asset protection trusts, then we want to make sure that we're dealing with all of the assets and not just the probate assets. Allie, are there any questions about the will so far?
Yep, just a few questions. At what age should someone have a will? As soon as they have assets or at age 18?
Um, that's a great question. I mean, most 18-year-olds don't really need a will. I mean, especially if they do a transfer on death with the bank account, like to their parents or something. But at the same time, it doesn't hurt to get one because if there's not a probate estate, it's fine. It's not like just because you have a will, you have to, there is going to be a probate estate. I think it's a good thing to just assess and think about doing a will then because, you know, and then it will be in effect until they change it when they get married or have children or anything like that. But then obviously, if not at 18, as soon as they have any types of assets, they should have a will.
Can personal property be in a trust and not go to probate?
Yes.
Okay. Does a person need an elder law attorney and a tax expert for estate planning?
Um, that's a great question. It really depends on the assets. So sometimes, depending on the assets and, you know, the planning around that and how they're going to pass them to children, we often meet with financial advisors together or an accountant. So, you know, that definitely not everyone doesn't need to do that, but people with complex situations, absolutely, we do that. We work with them. We work with the financial advisors and or the accountants to make sure we're setting it up in a way that is tax advantageous to the client.
In your opinion, are banks, by advising for TOD accounts, practicing law without a license?
Know if I'd say I don't think it's practicing law without a license. I do think that it is important to be careful with that because we're seeing it more and more, to be honest. And, you know, the banks are like, do this, it will avoid probate. And first of all, in Pennsylvania, I'm kind of jumping ahead of myself, but in Pennsylvania, probate isn't that big of a deal. There are some states that it is a huge deal. Pennsylvania, you know, the probate appointment itself is like 10 minutes and a few $100s. So, you know, putting a POD, a transfer on death designation simply to avoid probate makes no sense. It's just not a good option because a lot of times if you put TOD and you're putting it to one child or you make one child a co-owner of the account, that doesn't necessarily mean you wanted that child to get a gift of that entire asset, but now that's what you've done. So that's part of our work, is making sure that all of the assets make sense in terms of how you want your assets to pass.
What are the primary reasons for an asset protection trust?
There's a few reasons. I mean, one, let's say your child is really, or we're talking about adult children, but let's say your adult child is still pretty young, 20, and you have a sizable estate, or even, you know, not that sizable, but you don't want them to get a lump sum, you know, being that young. The other concern is a lot of times people say, you know, I want my child to inherit this. And if my child passes away, I want it to go to my grandchildren. Well, if your child passes away and they're married, it will, you know, without a trust, it will probably just go to their spouse because it'll pass by their will if they have it separate. And most people say, you know, I love my daughter-in-law, son-in-law, but if my child dies and they get like remarried, I really don't want my assets supporting their new family. I really want to make sure that it goes to my grandchildren. So that's one reason, is to, you know, maintain control over the assets as to what happens when your child dies. And then there's also the obvious situation of maybe your adult child isn't really great with money. Maybe they have a gambling problem. Maybe they have other kinds of issues that would prevent them from really being able to manage that kind of money.
You may have already touched on this in that answer, but can you explain in greater detail the asset protection trust versus beneficiary outside of trust scenario, probate versus not, and then probate versus non-probate?
Um,
Do you want me to
yeah, I'm
ask
not
this again?
Yeah, I'm not sure I totally understand the question. In terms of an asset protection trust that I'm referring to, that is a testamentary trust. So it's set up under the will. So it doesn't do anything to avoid probate. When you pass away, at that point, the trust will be set up versus, let's say, a revocable living trust that you fund during your life, which that would avoid probate. So it's different. Not all trusts, trusts that are set up by your will don't do anything with probate.
My wife and I have just one child. We want her to inherit everything. Do we need a will?
Yes. You still should have a will for a few reasons. One, do you want her to get it outright? Do you want it to, you know, there's just other considerations. Does it make sense for it to go in a trust? What do you want it to, what if she passes away before you? Then what do you want to have happen? So there's just a few reasons you should still have a will.
Then last question, are there tax consequences for TOD of bank accounts from parents to children or otherwise?
Yeah, that's kind of getting into some of the last things I was going to mention. So for in Pennsylvania, there's Pennsylvania inheritance tax of 4.5%. So by putting a transfer on death on a bank account, you're not avoiding any inheritance tax, even if you don't have to probate the will because all the accounts are TOD. You actually get a notice from the Department of Revenue saying the tax is due. So it's 4.5% for children, and there's other rates other than for children. So yes, you don't get out of paying any inheritance tax simply by adding transfer and death.
Okay, we just have one more question and then we can wrap up. Becky,
Okay.
mutual funds, IRAs typically rely on named beneficiaries. Can these assets be handled by trust instead of beneficiary designation?
No. So you have to update the beneficiary designation for those types of accounts. For like retirement accounts, we always need to have an updated beneficiary designation. In terms of brokerage accounts, if there is no beneficiary designation, which again, we're seeing more and more people are adding beneficiary designations to brokerage accounts. But if you do not, which you probably shouldn't, then they'll just pass by the will. And I don't want to say you shouldn't, but that's something that should be greatly considered, not just, oh, we're just going to add a beneficiary to a brokerage account. That's something that needs to be considered with your will and your estate planning documents. So last, I want to just say one more thing quickly. Not poor. What is poor planning? Poor planning is not making decisions, not getting your documents done. You are setting your family up for disagreements. You're setting it up for more difficulty. Everything is so much easier if it's laid out. One of the issues we see sometimes is a parent doesn't want to deal with setting up a trust for a disabled child because it's expensive, it's time consuming. So they just disinherit that child and give everything to their other kids, assuming the other kids will do the right thing. That's a huge mistake. So that's one issue. The other common thing that we see is people try and use it to save money or to make it, I don't know, maybe easier. It actually sounds harder to me, but using some kind of online system or doing a simple will for a complex situation and it just doesn't really work, or disregarding certain types of assets. So it's just important to take the time. And then we recommend it once you have your documents done, you want to reassess them every 5 years, or if you have any major life changes. Sometimes I review documents with clients and I say, yep, everything's perfect. And, we don't need to make any changes. Other times when we're reviewing and we're going through, they're like, oh, I can't believe I picked that person. I want to change that. So it's definitely something that you can't put away and forget about. A lot of times people do it when their kids are young and then look at it again 30 years later. But I recommend you just keep an eye on it.
Okay. Would you like to wrap up with just a couple more questions and then?
Sure.
Okay. If you don't have a will and are married, is it true a small amount of money goes to the spouse and the balance of the estate is divided between spouse and children?
No, this is the one I already answered. It really depends on this family situation. It's different if there's children from a different relationship. It just depends. So that would be we'd have to look at the specific situation. The other thing I wanted, because I mentioned real quickly about Pennsylvania, is inheritance tax. People also ask, what about federal estate tax? So real quickly, the federal estate tax exemption right now is 13.9, about give or take, million per person. So for a married couple, it's like $28 million almost. So it doesn't affect the vast majority of people. However, it is set to sunset down to $5 million a person at the end of 2025. That will be adjusted for inflation. But that remains to be seen what happens with the new administration and what's going to be done with that. But that's something to keep in mind because a lot more people have closer to 5 million per person than 14, almost 14 million. So that's coming up, in the near future. That's really all we have time for today, but thank you so much, everyone, for coming. And I'll leave it to Allie if she needs to say anything else.
Yes, thank you, Becky. And thank you, everybody, for joining us today. We will be having more webinars in the coming months on topics like life care planning and long-term care. So look out for those. Look out for those flyers in your email or social media. And then if we didn't get to one of your questions today, we can certainly follow up via email to make sure you get the information that you need. Also, if you'd like to learn more about our full range of services, our client service coordinators will be happy to speak to you. Feel free to reach out to our via our website, or you can call our office directly. Thank you again, everybody, and have a great rest of your day.